This is Executive Director Frank Caruso. We are in the process of admitting all of our attendees and placing everyone on mute. We want to thank you for attending today. We'll begin just as soon as everyone who's waiting in the lobby is admitted and placed on mute. So thank you. Give us about a minute here to get started. All right, Chairwoman Tabackin, looks like we're ready to go when you are ready to begin.
All right. Welcome to the July 30th Open Public Records meeting. GRC, Government Records Council meeting, sorry. Please rise for the pledge. I pledge allegiance
to the flag of the United States of America, and to the republic
To stand,
which stands
one nation,
one nation under God, indivisible,
with
liberty and justice for all.
and justice for all. This meeting was called pursuant to the provisions of the Open Public Meeting Act. Notices of this meeting, inclusive of call-in information, were faxed to the Newark Star Ledger, Trenton Times, Courier Post, and Cherry Hill, the Secretary of State, on July 25th, 2024. Members of the public attending the meeting via telephone have been placed on mute by the presenter. At the time that the council arrives at its public comment portion of the meeting, members will be taken off mute and given an opportunity to provide public comment. Please note that the council will strictly adhere to the 5-minute time limit. Additionally, copies of today's meeting agenda can be accessed on the GRC's website at https://www.state.nj.us/grc/meetings/minutes. Proper notice having been given, the secretary is directed to include this statement in the minutes of this meeting. Roll call, please.
Robin Bertabaki.
Present.
Michael Hine.
Present.
John Alexi.
Present.
Okay. Mr. Caruso, would you like to give the executive director's report?
Sure. Good afternoon, everyone. Hope everyone's having a nice day so far. In terms of our report, we always begin with our statistics. So since OPR's inception in July of 2002, the GRC has received 7,138 denial of access complaints, which averages about 323 denial of access complaints per 22 tracked program years. I'll note that the program years are tracked by fiscal year. We just got into fiscal year 2025 as of July 1st. And as of July 1st in fiscal year 2025, we have received 24 denial of access complaints. So of all of our complaints filed, 580 remain open and active, or 8.1%. A breakdown of where those complaints are at: 8 are currently on appeal with the appellate division, 30 are currently in mediation, 4 complaints are proposed for the Office of Administrative Law, 25 await adjudication by the Office of Administrative Law, 42 complaints are tentatively scheduled for adjudication at an upcoming GRC meeting, which includes today's meeting, and 471 complaints remain work in progress. Since program year 2004, the GRC has received and responded to 39,383 total inquiries, which averages about 1,875 annual inquiries per 21 track program years. As we always note, we did not track inquiries in our first year. So far in the current program year, again, fiscal year 2025, the GRC has received 129 inquiries, which is about 4.3 inquiries per workday. That is a little low, but I expect that that'll start to pick up here later in August and into September, which I'll get to in a minute. As far as our mediation numbers, since program year 2011, which began July 1st, 2010, and ending June 30th, 2024, 1,508 complaints were referred to mediation. Of those, 767 were settled, and 716 were referred back to the GRC for adjudication, and 25, as of, again, June 30th, remained active in mediation. Moving on to our outreaches. We have two scheduled for August. The first will be on August 7th. It will be held virtually and is hosted by the Institute for Professional Development. And we will have Records Management Services with us for that presentation. It's always a good partnership with RMS, so we're looking forward to that. The second presentation will be held on August 28th. It will also be virtual. It'll be hosted by the League, specifically addressing the upcoming changes to OPRA, which, as I noted at the previous meeting, the new version of OPRA will go into effect on September 3rd, 2024. At this time, we have several projects related to the new statute that remain ongoing, working to prepare as many things as we can ahead of the September 3rd deadline, but obviously focused on the long-term plans as well, with ensuring that the GRC can continue to meet its obligation of adjudicating complaints. So that is my report.
Right, thank you very much. We will now move into closed session. Whereas NJSA 10:4-12 permits a public body to go into closed session during a public meeting. And whereas the Government Records Council has deemed it necessary to go into closed session to discuss certain matters which are exempt from public discussion under the Open Public Meetings Act. And whereas the regular meeting of the council will reconvene at the conclusion of the closed meeting, now therefore be it resolved that the council will convene in closed session pursuant to NJSA 10:4-12B7 to discuss Charles Arentowitz v. Township of Long Hill, Morris, 2022-169 for an in-camera review, NJAC 5:105-2.8G. Be it further resolved that the council will disclose to the public the matters discussed or determined in closed session as soon as possible after final decisions are issued in the above cases. Could I have a motion to go into closed session, please?
I move.
Second.
Rose?
Stay here.
Robin Burke Zavakian,
Yes.
Michael Hahn,
Yes.
John Alexi.
Yes.
Frank?
All right. So for all of our attendees who are on the line with us, we are going into closed session. I estimate that it will probably be about 5 minutes. Stay here. Don't hang up. Stay in this room. As soon as we're done the closed session, we will return to this room and begin the public portion of the meeting again. So hang out here. You may not hear anything for a few minutes, but we will be back. And once we are, we'll go back into open session accordingly. So hang on, and we will be right back. If we could have everybody mute and the usual to go into the other room. Thank you. All right, everyone. Thank you very much for your patience. We're in the process of coming back into the meeting and we'll begin again shortly. Again, do appreciate your patience as we work through our closed session. We are completed and are in the process of getting all our council members back so we can continue the meeting. So we should be started again here in about a minute or two. Thank you. Okay, it looks like we have everybody back. So when you are ready, can begin
All right.
again.
All right. Could I have a motion to go back into open session, please?
I move.
Second.
Robin Beck-Vakin,
Yes.
Michael Hahn,
Yes.
John Alexi.
Yes.
Okay, we now will move into the approval of the minutes of the June 25th meeting. Is there any discussion on the June 25th, 2024 open session meeting minutes?
Chairwoman Tabak, I did want to note that we did have to make one minor change to the minutes. Presently, or in the draft minutes, the Commissioner Jacqueline Suarez was still noted as acting. She has been confirmed, so we just had to take acting out. It's a minor edit, but an important one, of course, that we had to make to ensure that it was correct.
Thank you. All right, as edited, are there any other comments? Okay, then as edited, could I have a motion to approve, please?
I move.
Second.
Robin Beck-Vakin,
Yes.
Michael Hahn,
Yes.
John Alexi.
Yes.
Okay, we move into new business, cases scheduled for consent agenda, administrative complaint disposition adjudication. An administrative complaint disposition means a decision by the council as to whether to accept or reject the executive director's recommendation of dismissal based on jurisdictional, procedural, or other defects of the complaint. The executive director's recommended reason for the administrative disposition is under each complaint below. So this is a consent agenda. I will read the cases and we will vote on them as a whole. The first two, Mr. Ritardi is recused. Frank, is he here?
He is not, so we can
All right.
proceed. Mr. Ritardi is not in attendance, so we don't need to mute him or anything like that.
All right, Kirk D. Campbell v. Hudson County Prosecutor's Office 2024-133, motion to file within time denied. And Whitney Straub v. Rutgers University 2024-176, motion to file within time denied. Could I have a motion to accept those, please?
I move.
Second.
Robin Beck-Vakin,
Yes.
Michael Hahn,
Yes.
John Alexi.
Yes.
All right, the remaining cases do not have any recusals. Rotimi Owa Esquire on behalf of African American Data and Research Institute v. West Milford Police Department, Passaic 2022-66, all records responsive, provided in a timely manner. Rotimi Owa Esquire on behalf of African American Data and Research Institute v. Highland Park Police Department, Middlesex 2022-69, all records responsive, provided in a timely manner. Rotimi Owo Esquire on behalf of African American Data and Research Institute v. Hapakong Police Department, Sussex 2022-72, all records responsive, provided in a timely manner. Rotimi Owo Esquire on behalf of African American Data and Research Institute v. Franklin Township Police Department, Somerset 2022-73, all records responsive, provided in a timely manner. Luis Eduardo Vigara v. Township of Berkeley Heights Union 2023-25, all records responsive, provided in a timely manner. Clarita Papajani v. Pascack Valley Regional High School District, Bergen, 2024-16. No record responsive to the record exists. Charlotte Bay v. Bravo Supermarkets, New Brunswick, Middlesex, 2024-161. Request made to a non-public agency. Tyrell L. Hicks v. Bravo Supermarkets, New Brunswick, Middlesex, 2024-166. Request made to a non-public agency. Banu Varkes v. Office of Assemblyman Robert Oth, 2024-181, not within the council's jurisdiction. Could I have a motion to accept all of the aforementioned cases?
I move.
Second.
Robin Vaktabakin,
Yes.
Michael Hahn,
Yes.
John Alexi.
Yes.
All right, we move into administrative disposition, uncontested voluntary withdrawals by complainant. There is no adjudication necessary, but I will read those. Kathleen Zurich v. Madison Public Schools, Morris, 2024-40, complaint settled in mediation. Kevin Kearns v. Township of Verona, Essex, 2024-59, complaint settled in mediation. Debbie Lynn Fitzgerald v. Neptune Township Police Department, Monmouth, 2024-105, complaint voluntarily withdrawn. Gladys I. Torres v. Township of Hamilton Atlantic, 2024-143, complaint voluntarily withdrawn. Gladys I. Torres v. City of Camden, Camden, 2024-153, complaint voluntarily withdrawn. Matthew B. Thompson, Esquire v. Township of Edison, Middlesex, 2024-159, complaint voluntarily withdrawn. Andrew H. Grolick, Esquire v. New Jersey Department of Treasury, 2024-178, complaint voluntarily withdrawn. Okay, new business cases scheduled for consent agenda administrative order. An administrative order means an order issued by the council requiring the records custodian or the complainant to perform a specific action in furtherance of the adjudication of a pending denial of access complaint, or taking other actions deemed appropriate to adjudicate a complaint in an expedited manner. The executive director's recommended reason for the administrative order is under each complaint below. There are no administrative orders with recusals, and there are no administrative orders without recusals. So we do new business cases scheduled for individual complaint adjudication. All right, the first two are with recusals, but Mr. Ritardi is not here. Parole, John Paul, the City of Jersey City, Hudson, 2020-209.
The council should accept the administrative law judge's dismissal of this complaint because of the complaint's abandonment thereof.
Thank you. Is there any discussion? Hearing none, motion please.
I move.
Second.
Robin Vaktabakin,
Yes.
Michael Hahn,
Yes.
John Alexi.
Yes.
Maria Diamante v. Rutgers University, 2022-61.
The custodian lawfully denied access to the complainant's OPA request to item numbers 1, 2, 5, and 6 because she certified, and the record reflects, that no records exist. Pusterhofer v. New Jersey Department of Education, GRC complaint number 2005-49, July 2005. The custodian did not unlawfully deny access to the records responsive to the complainant's OPA request to item number 3 because she properly referred the complainant to the location on the internet where said record could be located and also provided a responsive record. Rodriguez v. Keene University, GRC complaint number 2013-69, March of 2014. The custodian lawfully denied access to the complainant's OPA request item number 4 based on the privacy interest, NJSA 47:1A-1, and Diamante v. Rutgers University, GRC complaint number 2022-25, June of 2024.
Thank you. Is there any discussion? Hearing none, motion please.
I move.
Second.
Robin Vaktabakin,
Yes.
Michael Hahn,
Yes.
John Alexi.
Yes.
All right, the remaining cases do not have any recusals. Rotimi OO Esquire on behalf of Dolores Simmons, Obafemi Simmons, and Grace Woko v. Gloucester Police Department, Bergen, 2021-126.
The custodian's response was insufficient because he failed to address each OPA request item individually. NJSA 47:1A-5G, Path v. Willingboro Board of Education, Burlington, GRC complaint number 2007-272, May of 2008. However, the GRC declines to order disclosure because the custodian did so as part of the statement of information. The custodian performed an insufficient search to locate records responsive to the requested agreements. NJSA 47:1A-6 and Weiner v. County of Essex. GRC complaint number 2013-52, September of 2013, citing Schneebel v. New Jersey Department of Environmental Protection. GRC complaint number 2007-220, April of 2008. The custodian did not unlawfully deny access to the portion of the complainant's OPA request seeking court complaints because all records were disclosed. Danis v. Garfield Board of Education, Bergen, GRC complaint number 2009-156, ed sec, interim order dated April 28, 2010. The custodian lawfully denied access to the portion of the complainant's OPA request seeking complaints filed with the Cloister Police Department, alleging misconduct under the Internal Affairs Policies and Procedures, NJSA 47:1A-9A, and Rivera v. Union County Prosecutor's Office, 250 NJ 124, 142, and 43, 2022. The custodian's response to the portion of the OPA request seeking settlements was consistent with prevailing case law and the council's prior decisions. Libertarians for Transparent Government v. Cumberland County, 465 NJ Super 11, Aptiv 2020, and Moore v. New Jersey Department of Corrections, GRC complaint number 2009-144, interim order dated October 26, 2010. Thus, the council should decline to order disclosure. Although the custodian lawfully denied access to the redacted portions of 2 use of force reports, he unlawfully redacted the remaining 8 use of force reports, none of which contained information redactable under Executive Order Number 26, Governor McGreevey, 2002. However, the GRC declines to order disclosure because the custodian did so as part of the statement of information. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainants counsel shall submit a fee application in accordance with NJAC 5:105-2.13. Oof, man, that was an old school one.
Thank you. Is there any discussion? Hearing none. Motion, please.
I
I'll
move.
move. Second.
Robin Brett-Bakken,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Rotimi OO Esquire on behalf of Dolores Simmons, Obafemi Simmons, and Grace Wilco v. Buna Borough Police Department, Atlantic, 2021-183.
The custodian unlawfully denied access to records maintained by another agency pursuant to a shared services agreement, 47:1A-6, Burnett v. County of Gloucester, 415 NJ Super 506, Aptiv 2010, Machalik v. Borough of Helmetta, Middlesex, GRC complaint number 2010-220, interim order dated January 31st, 2012. Thus, the custodian had an obligation to obtain and disclose responsive records. Mayors v. Borough of Fairlawn. The custodian unlawfully denied access to the responsive records, NJSA 47:1A-6, Simmons v. Mercado, 247 NJ 2442, 2021. However, the GRC declines to order disclosure because the custodian did so on August 26, 2021, and as part of the SOI. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainants counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion? Hearing none. Motion, please.
I'll move.
Second.
Robin Brett-Bakken,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Rotimi OO Esquire on behalf of African American Data and Research Institute v. Mountainside Police Department, Union, 2021-287.
The current custodian did not fully comply with the council's October 3rd, 2023 administrative order. The custodian unlawfully denied access to the redacted portions of the responsive agreements containing payroll information, Palkowitz v. Hasbrook Heights, Bergen, GRC complaint number 2013-199, interim order dated February 24th, 2014, Rowarty v. Secaucus Board of Education, Hudson, GRC complaint number 2009-221, January of 2011. Jackson v. Keene University, GRC complaint number 2002-98, February of 2014. However, the GRC declines to order disclosure because the current custodian provided an unredacted copy to the complainant on August 8th, 2022. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainants counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion? The Jackson v. Kane University GRC complaint number 2002-98 is February 2004, not 2014.
Did I say 2014?
Yes.
Reading faster than I'm thinking, apparently. Thank you.
All right. Is there any discussion? Hearing none, motion, please.
I'll move.
Second.
Robin Brett-Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Thank you. Chris Kowalko v. Ramapo Indian Hills High School District, Bergen, 2022-42.
The custodian's failure to provide a date certain on which he would respond to the subject OPA request resulted in a deemed denial of access. Hardwick v. New Jersey Department of Transportation, GRC complaint number 2007-164, February of 2008. The custodian lawfully denied access to the complainant's OPA request item number 1, seeking oaths of office, because same are exempt from disclosure, NJSA 47:1A-1.1. Kaufman Jr. v. New Jersey Office of the Attorney General, GRC complaint number 2022-178, May of 2023. The custodian lawfully denied access to the complainant's OPA request item number 2 and items number 2 and 3 because he certified and the record reflects that no records exist. Pusterhofer, GRC 2005-49.
Thank you. Is there any discussion? Hearing none, motion, please.
I'll move.
Second.
Robin Brett-Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Rotimi OO Esquire on behalf of African American Data and Research Institute v. Ringwood Police Department, Passaic, 2022-70.
The custodian's response was insufficient because she failed to address each OPA request item individually, 47:1A-5G and PATH GRC 2007-272. The custodian performed an insufficient search to locate responsive records to the requested agreement, 47:1A-6, Sneebel GRC 2007-220. However, the GRC declines to order disclosure because the custodian did so on May 20th, 2022 and July 1st, 2024. The custodian unlawfully denied access to the portion of the complainant's OPA request seeking personnel information because a disclosed spreadsheet was derived from individual physical records. Valdez v. Union City Board of Education, Hudson, GRC complaint number 2007-156, February of 2008. The custodian shall thus locate and provide such records. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion?
Yes, Madam Chair, I want to make a quick correction and the conclusion. The final decision portion originally stated that it was going to give the custodian 10 business days to comply with the GRC's order. In accordance with our new policy going forward, they are now getting 20 business days to adhere to the council's order, and that change has been reflected in the conclusion.
Okay, so that's an amendment. So as amended, do I have a motion, please?
I'll move.
Second.
Robin Brett-Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Rotimi OO Esquire, on behalf of African American Data and Research Institute, v. Delaware Township Police Department, Hunterdon, 2022-71.
The custodian's response was insufficient because she failed to address each OPA request item individually, 47:1A-5G and PATH GRC 2007-272. The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified, and the record reflects, that no records exist. Pusterhofer GRC 2005-49. The complainant is not a prevailing party.
Is there any discussion? Hearing none, motion please.
I'll move.
Second?
Robin Bettebakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Rotimi OO Esquire, on behalf of African American Data and Research Institute, v. Ridgefield Park Police Department, Bergen, 2022-74.
The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified, and the record reflects, that no records exist. Pusterhofer GRC 2005-49. The custodian unlawfully denied access to the portion of the complainant's OPA request seeking personnel information because the disclosed spreadsheet was derived from individual physical files, Valdez GRC 2007-156. The custodian shall thus locate and provide such records. The complainant is a prevailing party. The parties shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion?
Madam Chair,
Yes.
as was similar to the case in 2022-70, the conclusion has given the custodian 20 business days over 10 business days to comply with the council's decision.
Thank you. So as amended, could I have a motion, please?
I'll move.
Second?
Robin Bettebakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Rotimi OO Esquire, on behalf of African American Data and Research Institute, v. Borough of Prospect Park Police Department, Bergen, 2022-75.
The custodian's response was insufficient because she failed to address each OPA request item individually, 47:1A-5G and PATH GRC 2007-272. The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified, and the record reflects, that no records exist. Pusterhofer GRC 2005-49. The custodian unlawfully denied access to the portion of the complainant's OPA request seeking personnel information because the disclosed spreadsheet was derived from individual physical records, Valdez GRC 2007-156. The custodian shall thus locate and provide such records. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion?
Yes.
Madam Chair, yes, I would like to note that the amendment, the conclusion has also been amended in this case to provide the custodian 20 business days to comply rather than 10.
Thank you very much. As amended, could I have a motion, please?
I'll move.
Second?
Robin Bettebakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Rotimi OO Esquire, on behalf of African American Data and Research Institute, the Princeton Police Department, Mercer, 2022-76.
The custodian did not unlawfully deny access to the portion of the complainant's OPA request seeking agreements because all records were provided. Danish GRC 2009-156 ed sec. The custodian did not unlawfully deny access to the portion of the complainant's OPA request seeking disclosable personnel information because all was disclosed. Danish GRC 2009-156 ed sec as well. The complainant is not a prevailing party.
Thank you. Is there any discussion? Hearing none, motion, please.
I'll move.
Second?
Robin Bettebakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Rotimi OO Esquire, on behalf of African American Data and Research Institute, v. Riel Borough Police Department, Monmouth, 2022-78.
The custodian's response was insufficient because she failed to address each OPA request item individually. 47:18-5G and PAV GRC 2007-272. However, the GRC declines to order disclosure because the custodian did so as part of the SOI. The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified and the record reflects that no records exist. Pusterhofer GRC 2005-49. The custodian did not unlawfully deny access to the portion of the complainant's OPA request seeking disclosable personnel information because all was disclosed. Danish GRC 2009-156 et sec. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainants counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion?
Madam Chair,
Mhm. Yes.
just a question for Sam, just to confirm this one has also been amended for 20 business days?
No, it was my understanding that the cases I had mentioned were the ones that needed amendments.
Okay. All right. Thank you very much.
Okay. Could I have a motion to accept, please?
So moved.
Second.
Robin Bird Sabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Scott Madlinger v. Berkeley Township Ocean 2022-114.
The $5 copying costs assessed by the custodian for records not responsive to the subject OPA request was unwarranted and must be refunded to the complainant. Liable v. Manalapan Englishtown Regional Board of Education, GRC complaint number 2004-51, September of 2004. The $2.50 fee for 50 paper copies of the records in redacted form was lawful, 47:1A-5B. The custodian is not required to disclose the records until after receiving the complainant's payment. Santos v. New Jersey State Parole Board, GRC complaint number 2004-74, August of 2004.
Uh-oh.
Thank you. Is there any discussion? Hearing none, motion, please.
I heard a nut. Oh, I'll move.
Second?
Hmm.
Could I have a
Go.
second, please?
That uh-oh might have come from John.
Was there a second? I didn't hear a second.
I think John froze for a second.
Okay.
Hold on. So I'll just to let you guys know, in the middle of Robin, you reading the withdrawals, my teams decided to switch all of its audio and video on me like 3 different ways. That might have just happened to John. So it looks like he's gonna try and get situated. Yeah, I don't know. There must be some update that pushed through because it did it to me, but then everything came back. It doesn't look like
Yeah.
it can.
Hi, Frank.
Yep, gotcha.
Yes, my laptop, it was doing something weird and then it just crashed. So I was able to get on my desktop.
Okay. Well, there you go.
Okay, we need a second in Scott Madlinger v. Berkeley Township.
I second.
Thank you.
Robin Bird Sabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
We did hear you say uh-oh, John, in case you're wondering.
Scott Madlinger v. Berkeley Township Ocean 2022-115.
The 15-cent fee for additional underestimated paper copies of records in redacted form was lawful, 47:1A-5B. The custodian is not required to disclose the records until after receiving the complainant's payment. Santos, GRC 2004-74.
August 2004.
August, yeah, well, yeah.
Okay.
That's
Is there any
short.
discussion? Hearing none, motion, please.
I'll move.
Second.
Robin Bird Sabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Charles Arentowitz v. Township of Long Hill Morris 2022-169.
The custodian complains Administrative order, the custodian comply with the council's in-camera examination.
Okay. Did everybody hear that?
Did I pop out again?
Yes, you did. On the first
Yes.
sentence.
Just for posterity's sake, so that all of our attendees can hear that in case anyone missed it. The custodian complied with the council's January 31st, 2023 administrative order. The custodian shall comply with the council's in-camera examination.
Thank you. Is there any discussion? Hearing none, motion, please.
I'll move.
Second,
Robin Brettabakin,
Yes.
Michael Hahn,
Yes.
John Alexi.
yes.
Yehuda Miller v. County of Cape May Board of Elections, 2022-232.
The custodian's failure to provide a specific lawful basis for denial resulted in an insufficient response, 47:1A-5G, and Swartz v. New Jersey Department of Human Services, GRC complaint number 2004-60, February of 2005. The custodian's clarified open request was valid. Mag Entertainment LLC v. Division of ABC, 375 NJ Super 534, 546, Aptiv 2005. Thus, the custodian's denial on the basis of validity was unlawful, 47:1A-6. The custodian unlawfully denied access to the requested ballots, which have been separated from any individual voter information, 47:1A-6. The custodian shall thus disclose 100 of the ballots cast in the 2020 general election.
Is there any discussion? The first sentence actually reads the complainant's clarified open request was valid.
I said that right.
To the custodians. Okay.
I'm just having one of those days.
Yeah, I'm having one too. I think we are. It's July. Okay. Is there any discussion? Hearing none, motion, please.
I'll move.
Second,
Robin Brettabakin,
Yes.
Michael Hahn,
Yes.
John Alexi.
yes.
Charles Arentowitz v. Township of Long Hill, Morris, 2022-664.
The responsive police study constituted interagency or intra-agency advisory, consultative, and deliberative material not disclosable under Oprah, NJSA 47:1A-1.1, Education Law Center v. New Jersey Department of Education, 198 NJ 274, 285, 2009. Giambri v. Sterling High School District, Camden, GRC complaint number 2014-393, Ed Sec, September of 2015. Thus, the custodian did not unlawfully deny access to the responsive record, 47:1A-6.
Thank you. Is there any discussion? Hearing none, motion, please.
I'll move.
Second,
Robin Brettabakin,
Yes.
Michael Hahn,
Yes.
John Alexi.
yes.
James M. Kiefer v. Township of Pennsville, Salem, 2022-669.
The custodian lawfully denied access to Oprah request item number 1 because she certified and the record reflects that no records exist. Priesterhofer, GRC 2005-49. The custodian lawfully denied access to Oprah request item numbers 2 through 4 under the Prevention of Domestic Violence Act, 47:1A-6, as well as 9A and NJSA 2C:25-33, and Van Bree v. Bridgewater Township Board, Bridgewater Township Police Department, Somerset, GRC complaint number 2014-122, October of 2014.
Thank you. Is there any discussion? Hearing none, motion, please.
I'll move.
Second,
Robin Brettabakin,
Yes.
Michael Hahn,
Yes.
John Alexi.
yes.
All right. Thank you very much. And thank you, Frank. That was a lot of room.
It was a roller coaster.
So that concludes the individual complaint adjudications. There are 2 court decisions of GRC complaints on appeal. Mr. Rosado?
Yes, Madam Chair, the first one is Owo versus Borough of Roselle Police Department, 2024 NJ Super on Pub Lexus 1479. On appeal from the GRC complaint numbers 2021-141 and 2021-196, the complainant appellant argued that he was a prevailing party in both matters pursuant to Simmons v. Mercado, 247 NJ 24, 2021, which was decided on June 17th, 2021. Regarding GRC complaint number 2021-141, the Borough of Roselle denied the complainant's request for CDR1 records on June 4th, 2021. The complainant filed a complaint asserting that Roselle failed to adhere to the Simmons decision. While the matter was pending before the GRC, Roselle provided the complainant with CDR1 records on February 1st, 2022. In affirming the GRC denying the complainant's prevailing party status, the appellate division found that Roselle's June 4th, 2021 denial of access was lawful at the time since it was prior to the Simmons decision. The court also found that Roselle's February 1st, 2022 production of records was in response to the Simmons decision, and the complaint was not the catalyst which changed Roselle's decision on disclosure. Regarding GRC complaint number 2021-196, the complainant argued that the Borough of Clementon denied his OPRA request on July 27, 2021, via email stating he should obtain the records from a judiciary website. The GRC held that the email was from an employee of Clementon's municipal court and not made on the custodian's behalf. The GRC also held that the evidence of record demonstrated Clementon's desire to fulfill the request, notwithstanding Clementon's failure to respond in time. The court agreed, finding that the complaint was not the catalyst which invoked Clementon's disclosure of records. So the court affirmed both matters. Next, in Eisen versus New Jersey Department of Children and Families, 2024 NJ Super Unpub Lexus 1269. In response to the complainant appellant's OPRA request seeking records referencing himself, the New Jersey Department of Children and Families denied access, stating that they could neither confirm nor deny the existence of records. In GRC complaint number 2021-1, the complainant argued that as a fraud victim, he was entitled to his own records. The GRC held that DCF's confidentiality regulations did not contain an exemption for victims and held that the denial was lawful. The court affirmed, finding that none of the regulations' exceptions to non-disclosure applied to the complainant in this instance.
Thank you very much. There are no complaints adjudicated in New Jersey Superior Court or New Jersey Supreme Court this month, and no complaints that are adjudicated in U.S. District Court. So it is time for public comment. The public comment period is limited to providing an opportunity for speakers to present suggestions, views, and comments relevant to the council's functions and responsibilities. In the interest of time, speakers will be limited to 5 minutes. Speakers shall not be permitted to make oral or written testimony regarding pending or scheduled adjudications. Would anyone like to make a public comment?
All right, so for our attendees who are on the line with us today, anyone wishing to make a public comment can unmute themselves by pressing *6 on your telephone. *6 will unmute you. We'll just need your name and then you can give your public comment at this time. *6, I typically give, roughly 30 seconds for our attendees to determine whether or not they're interested in giving a public comment. So *6 if you would like to give public comment. Give about another 20 seconds here. *6 for any of our attendees interested in giving public comment. Another 5 seconds. Anybody again, *6 if you are interested in public comments. Going once. Public comments going twice. All right, Chair, it looks like we have no takers for public comments today, so we can move on to the next agenda item.
All right, and the next agenda item is adjournment. So could I have a motion to adjourn, please?
So moved.
And I will second.
Robin Bertavaki,
Yes.
Michael Hahn,
Yes.
John Alexi.
Yes.
Thank you very much. Everybody have a great rest of the summer, and we'll see everyone at the end of August.
All right, thank you all. Have a good one. It's good to see
Take
everyone.
care.
Take care.
See you next month.